morning, everybody, and welcome to our webinar on fire safety, who pays and how. My name is Julia Davenport Cooper. I'm a partner at Temple Bright Solicitors. I'm joined today by an excellent panel of speakers. Kicking us off will be Mark Pawson, Technical Director at Hydrock. He'll be looking at what's happened to date and how we're in the current position we're in. He'll be followed by Alex O'Donnell, Account Executive at Hayes Parsons, and he'll be looking at the insurance market and trying to explain to us what on earth is going on. Alex will be followed by Lewis Cartwright, Director at Barclays, and he'll be telling us about a fund that they're working with Homes England on to provide funding for residential development. Following Lewis will be Mark Rees, Technical Head from Stride Treglowan, and he'll explain the design process in relation to fire safety. Following which, I'll do a quick run through of the impact I'm seeing all of this has on my consultant clients and the Building Safety Fund. Once we've finished the various speeches from the panel, we're running a Q&A session. So if you have any questions throughout the talks, please do ping them in. And if there's somebody in particular that you want to answer the question, pop that in the message as well. We're also recording this webinar, which we hope to be able to email out to everybody by the end of today. So without further ado, I'd like to hand over to Mark from Hydrock.
Thanks very much, Julia. Yeah, I suppose my job today is to set the scene for the significant changes to the built environment over the last couple of years. You know, we've gone through some dramatic changes in the last 3 years with advice and everything that's been issued. And even in the last 12 months, we've seen some of the biggest changes and challenges in the construction and built environment industry. And I just want to quickly paint the picture of how we got there. So if we move on to the next slide, we've got a timeline here with a lot of information on it. And that's purposeful, to be honest with you. I'm not expecting everyone to take everything in from this. But the reason is I just want to show you the amount of information that's been passed out to stakeholders, from designers, contractors, consultants, you know, even residents. You know, you can see the advice issued by the government displayed in green and the various dates. You can also see significant fires using, you know, or spread via external wall systems displayed on there with a flame as well. Going back to originally, you know, Lakanal House, which was a fire in 2009, similar incident, fatalities. Yeah, there wasn't really any changes in the industry, but rightly so. You know, we had the disaster at Grenfell Tower, and from that, there's been a plethora of changes, information, and consultation that's come out to the built environment, and we're trying to really respond to this as consultants, as designers, as residents, and we're trying to consider all the factors and all the changes. Not included in this particular slide, there's also been advice offered by the government. The consolidated advice note came out in January 2020, and then following that we had a number of other issued government documents, including obviously the response to the Grenfell Phase 1 inquiry, which came out in January 2020. We had the Dame Judith Hackett report, which happened back in 2017, but the actual consultation and the government response to the Dame Judith Hackett report, which was entitled Building a Safer Future consultation, came out in April 2020, April last year as well. And then even within the last 12 months, we've seen some dramatic changes. We've had the Fire Safety Act just passed there on the 4th of May this year, which we've seen changes in implementation to the Regulatory Reform Fire Safety Order, which again is the fire law, which basically there's been changes made to include residential external walls and communal areas within that particular regime. And we've got the anticipated draft Building Safety Bill, which was a response to the Building a Safer Future consultation. And that's the draft bill was published in April 2020 as well. So there's just so much information, and we can see why, you know, there's a need for these types of discussions and consultations and webinars to try and get our head around the sheer amount of changes and information that's been made. And then if we move on to the next slide, you know, one of the biggest changes in the industry is the EWS1, you know, the external wall survey. The industry responded to assist mortgage lenders with asset valuation, taking into account the advice offered by MHCLG. And we've seen the creation of this EWS1 external wall risk assessment. It was introduced by the Royal Institute of Chartered Surveyors It was a collaboration between them, UK Finance, and the Building Societies Association as well for valuation purposes. Again, even this has undergone within the last 12 months significant clarification and changes. It was only supposed to be carried out originally in buildings over 18 metres or where there was a specific concern. However, as I say, since there's been a number of revisions, since its initial publication, and there was an update just recently on the 5th of April, which kind of brought out new guidance. Sorry, the 8th of March to be implemented by the 5th of April, which brought out new clarifications to help homeowners, valuers and surveyors try and identify, are there any issues and what the risks are. So this was a response to the MHCLG advice. So as you can see, just within the last couple of minutes, there is a lot of changes. It's probably the most drastic change that the built environment and construction has seen in the industry in decades. And it's all happened within the last kind of 12 to 24 months. So there's a huge change there, and everyone's trying to, I suppose, understand and grasp what's actually happening here. So that's it for me, just painting the picture to set the scene of where we are today and how we got here. I'll just like to introduce, I think it's Alex that's next, yeah.
Yeah, brilliant. Thank you, Mark. Yeah, so moving on from that and looking at how this situation's impacted the insurance industry, it has obviously impacted it massively, but before you can look at that impact, you need to look at where the insurance industry was before it cropped up. So currently, the market as it stands, we're in a hard market, which basically means that premiums are on the rise and capacity is being reduced. So it's very basic supply and demand issues. So although there would never be a good time for this sort of thing to crop up, it couldn't have happened at a worse time for the insurance sector, it's fair to say. So there was already pressure on the key thing being availability and affordability of insurance. That was true of certain sectors, professional indemnity being one. But for buildings insurance, the EWS1 system, that's been brought in, as Mark mentioned, developed by RICS to help lenders establish the value of an asset. The form itself, we can just go on to the next slide, sorry, if you look at that. So it's not a binary pass or fail test. It's a grading system of sorts. If you follow the flow chart through, you'll see there's 5 possible outcomes. Rated A, there's 3 options, and B, there's 2 options there. 4 of those shouldn't really cause insurance buyers any major problems. One of them is a problem for the industry. But if you're in an A1, 2 or 3, or a B1, is as long as you've got a reasonable and prudent insurer who's alive to the issues, it shouldn't cause you any major problems. To say there might be some costs involved, but it shouldn't be a panic or can we get cover? Will it be affordable? So we're going to look mainly at just the B2 rating where that's been recorded. And that essentially means that the building has not achieved an adequate standard of fire safety. You're likely going to require remediation works and interim measures, which again is going to come with cost. It's worth mentioning that if you do get an A1 or other rating, not a B2 rating, that information certainly would be deemed to be a material fact for insurers. So as soon as you get your results, this is something that you would need to disclose to the insurer as soon as practically, as soon as you reasonably could. Where you do that and you've got a B2 rating, this flowchart, when you look at it, it ends at the rating that you get. If you've got a B2 rating, that's really, from the insurance side of things, that's where your journey will actually start. It'll start off a chain reaction of sorts leading up to your next renewal terms. And so it's essential for clients to understand what this will look like and what things need to be considered in terms of time and costs. The key reason that this is a major issue for the insurance sector, in particular for B2 ratings, we heard there that RICS and the lending industry, formulated this process. That the insurance industry was not consulted on this or involved in any sort of real meaningful way. The result of that means that there's no standard industry approach for insurers when they get this information in. You also have to consider then that in terms of protection for leaseholders and people who buy insurance, there isn't an insurer of last resort. So we've seen across the pandemic, certain classes of insurance have had support from the state because they've been deemed critical. If you think about the film industry, trade credit insurance, the government has stepped in there. They haven't so far done that with this. So there is no insurer of last resort, which means you will be looking to the insurance market to provide your terms, and the market will decide whether it does or doesn't. Also, there's no price cap on insurance premiums to ensure affordability. So again, these are the issues that are going to crop up, and you need to be sort of prepared, how to deal with them. But if we go to the next slide, please. So availability and affordability. So those are going to be the two major issues. There's a lot of consultants on this webinar, I know. So if you're purchasing professional indemnity insurance, these are exactly the same issues, and in part for the same reasons outside of the EWS1. So in the absence of any sort of clear industry guidance on what insurers will expect of you when you get a B2 rating, we're just going to set out some of the key areas that you're going to come up against and areas that the underwriters will focus on, and hopefully that's of use. The first thing to say, when you get a B2 rating, as I say, it's a material fact, so you have to disclose it. Your current insurer is going to be your best friend. They might not end up being your best friend, but that's where you'll start. They've got the existing relationship, the previous year's premiums, but importantly, they should feel some sort of social responsibility towards leaseholders who find themselves in this situation through absolutely no fault of their own. The hardship and anguish that leaseholders feel at the moment is real, and insurers, as part of our society, they do have a role to play, and they've got a duty not to abandon their customers in their time of need. So we'll look at the sort of risk and technical information that they're going to require, but we shouldn't lose sight of that fact, and you'll need to push that on insurers as well to make sure you maximize the results, because they have to recognize and acknowledge that. So approaching the insurance market when you have got a B2 building. If we could have the next slide, please. So in terms of a premium, how do insurers come up with your cost? What are they going to charge you? One of the key things they'll look at is frequency and severity. So how often will claims occur, and when they do occur, how bad will they be? In very basic terms. Frequency, you need to address that as much as you can in terms of what's in your control. That's more going to be around behavior and activities. So if you think about things like what leaseholders getting up to in terms of cooking equipment, deep fat fryers, barbecues on balconies, control of contractors who are working on the premises, all of those sort of things, risk management, you can address them. It won't be enough just to be doing those things. You'll need to be able to articulate that as well. When it comes to severity, that's the big issue that needs to be addressed, and that's where a lot of time and cost is going to come into the equation. So insurers will be expecting you as a freeholder or as the residential management company to have fully understood all the issues that have come up in that B2 rating, and importantly, they want you to be active in developing a plan to remediate. They won't necessarily expect you to have all of that by the renewal date, but certainly they'd want comprehensive and robust information to show that you've got a plan. They'll probably expect you to have taken legal advice, looked at sort of cost benefit analysis of any interim measures. You'll need to be quite far along in that path as much as you can be. Where possible, you need to get a team around you as well to provide that support. We saw just the amount of information on Mark's slide there. There's a lot to take in and there's a lot to navigate. Another thing you'll need to help the insurer understand is the true exposure, because if they're concerned about the severity of claims, they need to understand what's the maximum amount they're going to have to pay out. You'll probably need a recent reinstatement cost assessment, i.e. within the last 3 years, because you need to be confident that you're telling the insurer the correct information. You'll also need to adhere, of course, with any fire risk assessment recommendations. Now, whilst this wouldn't be an insurer-led requirement, it'd actually be a legal requirement. So that's a given, but again, you need to consider the time and cost and how you're going to implement those. I mentioned about the behavior, so that is a frequency issue, but it's also a severity issue. So you do need to articulate all of the risk management standards. When it comes to things like contractors, making sure there's management in place and they operate a hot works permit system for when they're using heat equipment, or where possible, you can manage that out as a process across the block. And even the basics like auto door closers, AOV systems, and dry risers, you need to know, are they functioning are they maintained? What's the situation, and can you show that to the insurer? In terms of there being no standard approach across the insurance industry, that is the case. Some insurers will be doing this off their own bat, but they haven't come out and actually said this is what we need and we are open for business. If we can just go to the next slide, please. So Aviva Insurance, one of the biggest insurers, very familiar name. They've recently come out and said that actually we've got a lot of these buildings on our books already. We're quite alive to the fact, and we know what we're doing. Subject to certain things being in place, you can have a conversation with us about B2 rated buildings. Now, as I say, other insurers have this approach, but none have come out yet and put it in writing and said, okay, these are our parameters. We are open for business of sorts. That is a really, really good positive step for leaseholders, and it goes some way to helping with availability and affordability challenges. But again, we're not yet at the state intervention market failure stage, and positive step, but more is needed essentially. So in summarizing who pays and how, the insurance sector, much like the financial sector, is heavily regulated, and they're not going to be expected to take on an acceptable risk. They can't, because they have to be prudent insurers. It goes against the way they're regulated. I think it's only going to be the state stepping in that would be able to provide support around affordability and availability. But until such time, all of these things will need to be factored in to your next renewal. So that's a whistle-stop tour of the insurance industry while my personal phone rings, which is terrible, excuse me. And I'd just like to hand over to Lewis Cartwright now of Barclays. Thank you.
Good morning, everyone. My name's Lewis Cartwright, and I'm a director at Barclays in the real estate industry team. I appreciate that this presentation isn't specifically about fire safety, but I wanted to talk about what we've been up to in terms of funding residential development. If you could just move on the slides to the next one, please. So today I'm going to cover our housing delivery fund partnership with Homes England, which has been in place since 2019. Feel free to ask questions during or at the end, but I'm happy to cover anything that may be on your mind from a bank funding perspective. So this is the contents, this is what I'm going to cover today. Next slide, please. There we go. So quick overview, what are we actually doing? So Barclays and Homes England are working together to provide a £1 billion residential development fund to help tackle the UK housing crisis. And this roughly splits into Homes England providing half of the mezzanine debt and the bank providing the rest within that fund. So our corner is roughly 3/4 of the whole fund, 750 million. Funding is provided to develop homes for rent or sale, including social housing, private rented sector and build to rent. I mean, the key priority why we're actually doing this is that we need to support SME sized developers with an established track record to realise their growth ambitions. I mean, put simply, the core ambition of the fund is to deliver more homes more quickly. And we're looking to support existing developers and also help new entrants to the industry as well. Next slide, please. So typical loan tickets are between £5 and £100 million, which is normally a 10 minimum unit scheme, is where the scheme starts. The minimum £5 million, the way we cut this was that it was a site that would provide 30 homes at 65% loan to gross developed value, assuming an average sale price in England of about £270,000. I mean, the product is structured as a combination of senior and mezzanine debt, where the maximum leverage is capped at 80% of total project costs. I mean, this broadly brings us into line with most of the other sort of secondary type development banks. Senior debt is provided solely by Barclays, and the mezzanine debt is provided equally by us and Homes England on a joint basis. We underwrite loans on a deal by deal basis, and they're sized against development costs, so the loan to cost ratio. and the value of the development, which is the loan to gross developed value, or loan to GDV, as we call it. The product effectively gives us the ability to compete against secondary lenders in the development space, but utilizing probably lower cost debt to the borrower, and also much larger deal tickets. Next slide, please. So the key features continued. So student accommodation and service departments are unfortunately out of scope, but we can do build to rent blocks subject to satisfactory repayment source, which is normally a refinance to term funding on an investment basis. But often we find the challenge with build to rent schemes is the higher leverage doesn't translate to term finance because of the lower yield in the residential investment market. I mean, we've worked hard to make sure the document suite is as straightforward as possible. Famous last words, but all of the document suite is pre-agreed between us and Homes England, so it's effectively a relatively straightforward process. And next slide, please. So the core eligibility criteria. So the first thing to say is that all transactions have to be approved by both Barclays and Homes England independently, and we have to prove that the scheme wouldn't progress as quickly without using the higher leverage product that this offers, or where, for example, the scheme would aid innovation. So we are very much looking for modern methods of construction or eco homes, those sorts of projects. And the fund aims to deliver affordable homes and increase access to home ownership. So high-end luxury homes wouldn't necessarily work, but it would allow for a high price point if the pricing is in line and affordable for the location. So the sites have to be in England, hence Homes England involvement, and there can't be any offshore WYSI ownership structures. As with all development transactions, the bank's looking for sponsors who have a track record of delivery in the sector and the location. Next slide, please. So the important funding requirements, getting down to the nitty-gritty. So all necessary planning, approvals and permissions enabling the scheme should be in place at financial close, and the developer equity has to be fully invested before any debt is drawn. Also, the development must be fully funded, i.e. it shouldn't be reliant upon additional funds beyond the developer equity and the debt finance. So it's what we would call a fully funded structure, and this generally tends to work better for apartments where you've got to finish the block before anyone can actually move in. We're keen to support the delivery of family homes and would consider exceptions to a fully funded scheme, i.e. allow for recycling of sale proceeds back into the structure on a case-by-case basis. Clearly, fully funded structures don't necessarily always work for family housing schemes. Appropriate cost and interest overrun contingency needs to be baked into the deal, and it should either be lent within the structure or provided by some other external party by guarantee or whatever. We normally appoint independent surveyors to monitor the progress of the scheme and external lawyers to draft all the documentation. Satisfactory security will be required in line with transactions of this type. And then just turning to cost, we roughly say that the senior interest margin is in the realm of about sort of 3%, and then the mezzanine finance cost is in the realm of sort of 8%. So the all-in cost normally starts with a 4, which is generally cheaper than other development lenders in the sector. And then, of course, the other benefit here is we can do quite lengthy terms. So we could do between 2 and 5 years if it was a particularly large, complicated project. The repayment sources, obviously selling of the completed units, and then possibly term refinance if it's a PRS scheme. And then just turning to the actual interest calculation, it's SONIA linked, not LIBOR. I thought I'd better bring that up because SONIA's on everybody's mind, because LIBOR's going at the end of this year, and we've been working hard on that risk-free rate transition project. I think that's probably me. Happy to leave it there. I'll take questions whenever, and I'll pass over now to Mark at Strides.
Thanks, Lewis. I'm probably going to take things in a slightly different direction from what our panelists have discussed so far. I would like to reiterate what Mark Parsons of Hydrock was saying, that in the last 12 months, 24 months, we've seen a seismic shift in the industry in its relation to fire, but there has been knock-ons to that. It's not just fire. There is a much larger scrutiny of our work, and rightly so, really. But if you can just go to the next slide, it really has been back to school for the industry. I think they're partially because of the amount of different specialists that we have. There has been a shifting of responsibility in some respects. What we've seen over the last 12 months is possibly as a result of insurance, but also the industry looking at it itself. A lot of that responsibility has been taken back on board by all the different consultants, such that we've really seen a change where, and Mark probably has witnessed it, where we are really questioning the other specialties about what they're saying in terms of our designs, solutions, that sort of thing. But in terms of back to school, everything to do with fire has been re-looked at, and I think even from a regulatory perspective, we've gone back and looked at our different frameworks, our routes to compliance. Obviously, we've got Part B. As designers, we can also use some of the British standards that provide a route-based assessment. So that's BS 9999 and BS 9991. And then for healthcare and schools, there are other guidance documents such as HTM 05 and BB 100. We can use all that, and then of course there's fire engineered solutions, which of course we will still as professionals question the recommendations, but ultimately that's where we cede to the fire engineers who are the experts in the field. So when we look at fire from a architectural perspective, I think there was in the industry confusion as to the different ways fire propagates. We still have situations where we're talking to people and there is a misunderstanding between fire resistance, spread of flame, and combustibility. And all the regulatory changes that have come through has increased people's awareness, but there still is this underlying confusion as to those three different things. And obviously to do with relevant buildings and the external wall, the major change that sort of occurred with the combustibility of the external wall, we're constantly having discussions about what combustibility as opposed to fire resistance sort of means. The other thing is it's had major effects to in terms of when we design, we ultimately need to find certified solutions. Otherwise, we have to once again lean on fire engineers to provide comment. Now, one of the things that came out of the regulatory changes, desktop studies were at least with regard to the external wall, deemed non-compliant. You couldn't actually have a desktop study done unless it was done by a certifying body. So ExoBFI, that sort of thing. The impact, though, of that, it does have cost implications, because it does send you down certain routes with certain suppliers who have already done their testing. The testing costs a lot of money to do, so they tend to be the larger suppliers. If we go to the next slide, the question to the industry is, is it as business as usual? Is it just something that we've adapted to? The fact is, it's not business as usual. Now, I think Alex and Lewis were sort of talking mainly about buildings that already exist. On those buildings that already exist in the EWS 1 form, obviously there's a major cost for developers and potentially leaseholders for those buildings that require rectification work. The impact from a design perspective is it is a risk-based assessment that is done. So you do need to put together a professional team that have the PI cover, that can do that risk assessment. And what you'll find is that prices a lot of the small architectural firms, at least, out of the picture, to do a recladding or pick up a recladding job. Obviously, PI cover has increased, and so it tends to be the larger architectural companies that can cover those extra costs and the extra risk. And then during the risk assessment, it is really down to the professionals, such as the fire engineer, as to the level of rectification work that may need to happen. And once again, as architects, we need to question all those recommendations, and unfortunately, those costs, like I said, the cost of the professional to engage the professional, but then also the cost to do the rectification work is really on the developer and the leaseholder. There is also on the new build side of things, there's the latest changes that have started to come through as a result of Dame Hackett's report, the golden thread and the gateways, which will be coming into force, at least with regard to relevant buildings. As of yet, we're unsure of how that impacts costs, at least in the early phases. At the moment, the Gateway 1 forms simply a document that you put in with planning. Generally speaking, most of the document's fairly easy to use, and I don't envisage really much cost coming from that, except for the fact that once again, you're led down with certain supplier routes. The obvious one is sort of brick slip construction. If you have a building over a certain height, there's only a few suppliers on the market that have sufficient testing to allow you to use the brick slip systems. If we then go on to the contractor side, which Stride Triple A tend to see a bit more of, I'd say between 60 and 70% of our work is with contractors. The costs there are also considerable, and it's not only funding insurance for the main contractors and their subconsultants or subcontractors, sorry. But it's also in relation to their methods of construction. And this is where we're finding the biggest difficulties at the moment, because if we look at the wider regulatory framework and the wider sort of initiatives in the built environment, sustainability being one, the fire regulations and CLT begin to cause us problems. Steel frame, the same thing. We're finding at least some of the detailing around steel frame and finding verifiable, certifiable solutions is proving very difficult. Concrete frame is more costly a lot of the time, but from a fire perspective, it's fantastic. From a sustainability perspective, it's terrible. So we're finding a lot of complication. But what's sort of happening is as architects, we're having to request in different appointment documents that the specialist fire engineers are involved at latter stages to be able to provide comment. A lot of the time, the commentary is not necessarily on their PI. It remains with the architects, but they're needed nonetheless to help support some of the solutions. If we can't, because there aren't, unfortunately, certifiable solutions for everything. And at those instances, we rely on fire engineers to provide us with a risk-based assessment. We then take that away and we assess the risk internally within our business and whether we're happy with it. We then, if you look at fire protection system installation, what we're finding is contractors are having to employ a specialist to go around, check the installation and check the certification. So that's an additional cost that they're wearing currently. Well, they will pass it on, but in order to check the quality of the workmanship around builders' work penetrations. And so what it leads us to sort of question and what keeps on coming up is this idea of a quality control manager and a clerk of works. Obviously, a clerk of works is not a common thing these days, especially with D&B contracts, but the issue with requiring certified solutions and being pushed down a certain design methodology and construction system, it really takes out some of the cost benefits that could be awarded with a D&B form of contract. And so what's tending to happen is fire is discussed very early on when the contractor comes on board, because they're starting to understand that their avenues for different methods of construction become limited. So, I mean, all in all, in terms of who's paying, obviously the contractor will pass these on to developers. I think the focus has been on relevant buildings, and rightly so, and that's where the major costs for developers, homeowners, leaseholders is being felt, and will be felt. However, it is shifting into other typologies. Like I said, the industry as a whole is looking at how they do things, and those costs and that quality checking that really is important will trickle through. And I think it's not that gone are the days of sort of the undercutting of our fees and the rest of it, but I think there will be an increase in cost, development cost associated with the requirement to really get these things right. So that was me from a design, fire safety and design perspective. I'm going to pass on to Julia.
Many thanks, Mark. I think it's fair to say that for the last 12 months, for businesses and individuals, it's been a particularly tumultuous time. And I think for businesses, it's been somewhat of a triple whammy between Brexit, COVID and obviously the legacy of the Grenfell Tower disaster. And I think there's two particular areas of my practice where I see all of this manifesting. The first is in relation to consultants who have obviously been through and are repeatedly going through annually the PI renewal process, and it's proving pretty traumatic, to be honest. People come through the door looking like the walking wounded. Next slide, please. Oh, next one again. So I think particularly over the last 12 months, these three challenges have really brought businesses to the point of looking perhaps a bit more closely at their internal risk management processes. And I've certainly noticed that in the last 12 months, I think with the overlay of COVID on top of everything else, it's brought a lot more people through the door looking for help in how they can tighten up their risk management. And the logical starting point for that, from my perspective, is setting up or updating terms and conditions that consultants are using to make sure that not only are they up to date with the law and a robust set of terms for protecting the consultants, but importantly that they now match what the PI cover that they can actually achieve. And as we were hearing from Alex, you know, the amount of cover available, the sub-limits and the exclusions and excesses are all on the move and not in a good way. And so making sure your terms keep up with the cover that you've actually got has become increasingly important. As a secondary exercise for those consultants that sub-consult, I've spent time putting together forms of sub-consultant appointment to mirror the main consultant terms and step down risk where appropriate, and again to make sure that these all tie in with the insurance that's currently available. Next slide, please. The second area of my practice that has really taken off, not sure if it's a good thing or a bad thing, but it's in relation to the Building Safety Fund. So this was the fund set up by the government to help leaseholders pay for the remediation works to remove unsafe non-ACM cladding. There was currently about 5.1 billion committed to the fund, but I think the industry thinks that the real value likely to be needed is closer to 15 to 20 billion. So on the face of it, whilst it looks like a big number, clearly there's already what looks like to be a funding shortfall. And the fund is pretty clear that it will be allocated on a first come, first served basis, which feels slightly uncomfortable, I think. The fund, whilst it is good that there is a fund, there is a number of shortfalls with it, I think. For example, it kicks in for buildings 18 metres, 6 stories high. For those that are less than that, then there's a low interest government loan where the repayments are capped at £50 a month. And I just wonder, given the value of a lot of these remediation works being several £1,000,000, how long it's going to pay off such loans. The applicants to the fund also have to confirm that they've exhausted all other sources of funding, and the main one for that looks to be pursuing developers who originally built the building. On the face of it, that sounds pretty straightforward, but the practical reality that I'm seeing is that actually nobody has a complete pack of the original construction documents, building contract, appointments for that build. And so it puts you in the difficult position that you haven't got the documentation to be able to analyse what, if any, claim you've got and begin to figure out what the chances of success of any claim would be. It's certainly not going to be overly easy to go back to the developer or the consultants and say, can you give me a copy of the document that was signed back then, particularly if they think you're about to launch a claim against them. The other problem with that backward facing exercise is that there's no government funding for it, and so leaseholders will need to pick up the cost for that, and I think for some leaseholders that's simply not going to be possible. The fund was set up and there was a submission deadline of July last year, and I'm just not sure that with the pandemic and all that there was going on, that all eligible buildings would have actually recognised and been able to apply by that date. I just wonder what is going to be done to sweep up those. Another sort of shortfall, where it was a shortfall until recently, was that there were very tight timelines for the fund, and if you missed the timeline, you were out effectively. Stage 2 applications were meant to be submitted by the end of this month, but we've heard on one of our projects this week that that timeline isn't a deadline as it was originally announced, and so there does seem to be a little bit of flex, and I suspect that's because of the difficulty of the complexity around the property aspects, the construction procurement methodology, and all the public procurement and state aid requirements that need to be satisfied. They're certainly proving challenging on the schemes I'm on. Next slide, please. So in terms of the structure and the documentation for the fund, to my mind, it is a bit complicated. Reminds me a bit of the old PFI and PPP type schemes. So sitting at the top is the agreement between the leaseholder and the ministry, and if you're in London, the Greater London Authority, and outside London, Homes England. It's a prescribed document. There's very little room for negotiation, but applicants will need legal advice on it because they do have to warrant how the property is held, how the construction procurement is being run, and make some declarations around state aid. And in my experience, the state aid bit is the bit that's caused the most frustration. The document was drafted pre-Brexit, and of course at 31st of December last year that went up in smoke, and has only just in the last couple of weeks been updated to reflect the current public procurement and state aid regime, which isn't very helpful when you've got a 30th of June deadline. Sitting alongside the grant funding agreement is the pre-tender support agreement, which enables the fund to allocate 10% of the cost of your works to enable applicants to pay for all the work that needs to be done to be able to submit a stage 2 application. You effectively need to have your consultant team on board, done all the design and tendered and selected your contractor, and be ready to go if you get your stage 2 application approved. It again is a prescribed document, so there's not much room for negotiation on it. Sitting below that, you'll therefore then need your appointment documents with your various consultants and a building contract, and there's no prescribed form for those. However, it's worth noting that there are specific requirements in relation to the fund that mean that you are likely to need legal advice on those. Because the industry standard forms like JCTs for building contracts or REBA forms for architects won't cover the fund specifics. The final set of documents are the warranties to the ministry. They again are in a prescribed form, perhaps unsurprisingly. There's quite detailed provisions around cladding and fire, which is lovely, except for the fact that the consultant team then, we've find it difficult to square those obligations off with the PI cover that they can actually get. So I think that's been a bit of a learning curve for all involved. So in summary, I would say that if you or clients are progressing an application for the Building Safety Fund, you need to do it really as fast as is possible, because it is a limited fund and it's on a first come first served basis. And I think certainly in my experience, I see people that have perhaps focused on that backwards exercise of chasing down a developer, but that is going to be a very time consuming process if it yields any money at the end. And so I would, recommend that the government funding is the sort of main focus of attention. And that's basically the end of my whistle-stop tour of the impact on consultants and the Building Safety Fund. We have got some questions in, and so I'll start working through those. So I've got one comment in from Andrew Bannister, and I think this is probably for Alex, maybe possibly Mark Paulson. The question is, you've mentioned that a B1 rating on the EWS1 form shouldn't mean your insurer runs off scared, but what about situations when you remediate but can still only achieve a B1 rating, but you can't comply with the ADB as some combustibles remain? Example being a building over 18 metres that have SIPS panel construction. How much of an impact will that have on insurance and mortgage lenders?
Thank you. Yeah. So as far as insurance goes, it's difficult. As I mentioned earlier, it's not a pass or fail result. So it shouldn't be binary. We can insure you, we can't. It's more about articulating how the risk is managed, what measures have been put in place. The insurer is going to need to be confident that you've got a handle on that. That if a fire does occur, that you've addressed the severity and the spread issues, whether that's through common alarm systems, amendments to the evacuation procedure. All that stuff just needs to be articulated. Again, because there's no standard approach, there's politicians' answer, but without a standard approach across the industry, there's no standard answer to that question. It'll differ from insurer to insurer. So as long as you've got a handle on, the risk management side of it, and you've exhausted your options in the market will decide whether that's an issue for them or not. I know that's not a great answer, but all you can do is put yourself in the best position to make it a yes answer from an insurer by showing them that you've managed the risk. Apart from knocking the building down, some of this stuff is, it's going to have to remain. So I don't think, insurers shouldn't abandon people and buildings for this. There should be solutions available. And the only way to ensure that is all the things we mentioned before. So I don't know if that answers it fully, but that's as much as I've got for that one, sorry.
If I can jump in, we've got a project currently that is a similar situation where it has SIPS construction. My advice is to hire Mark there. Essentially, it is a risk assessment situation, and you basically need a fire engineer to risk manage that risk. The timber will remain in the construction, so it's simply what you, as Alex was saying, it's simply what you have done in order to mitigate that risk.
Yeah, and if I could just kind of cap that off, Alex and Mark are absolutely right. It is a risk assessment approach. The problem is there's not a standardized industry approach to this, and there's a severe lack of actually fire engineering professionals in the market. I think the whole insurance, debacles maybe worse than that a wee bit as well, in terms of small to medium-sized fire engineers now not being able to have the PI cover to do the kind of external wall work. But certainly, if you're taking a B1 approach, that actual approach is that the competent fire engineer has risk assessed, and that's the kind of key terminology. So you take into account the building combustible materials, the construction methodology. As Mark Rees kind of picked up on, the industry only now, I think construction and others are starting to pick up on the fact, well, there's a difference between the combustibility test, the fire, the 8414 test, the fire retardancy. There's differences in these tests, differences in these construction materials. So you need to be competent and knowledgeable of what you're doing in that sector to perform a decent risk assessment in order to get that kind of B1 rating. And the thing is that you need to be able to, I always think about it like showing you're working. You can't just give the answer B1, you need to show how you got there and the risks involved and how the mitigation measures that are included in that and how you deem that satisfactory as well. So I think that's the difference. You need to show exactly as a competent engineer how you got to that conclusion. And that's certainly the approach that we would be taking.
Many thanks, Mark. As a sort of a subsidiary question around EWS, we've got one around at what point should clients have an EWS carried out? Where does it apply, for example? Does it only apply to all buildings that have recently been built, refurbished, or are they, or for those on the market as well?
I'll pick that up since everyone else is silent. That's okay. Obviously the RICS have come out with guidance. The guidance was fairly, I don't want to say vague, but at the start when it first came out, it kind of seemed like open season on all buildings. They have tried to whittle it down to, certain buildings where there's a concern over a story of 18 metres that have a percentage of cladding on the wall. But certainly the EWS1, specifically that certificate, there is a route or a path you can follow on the RICS website. You answer a few questions and it will ultimately determine whether or not your building is applicable. Now, saying that, and this is where maybe Lewis would come in or someone else, mortgage lenders are still asking for EWS1 certification on buildings that maybe aren't applicable or deemed as applicable under the RICS website. And this is where the grey area comes in. And there's still lenders out there, there's still providers looking to see, well, we need this certification. You know, we need to understand what the risk is here, even though if you were to follow that systematic methodology set out by RICS, it maybe wouldn't be applicable. The other thing you have to consider as well, you know, EWS one aside, is that the Fire Safety Bill, or the Fire Safety Act as it now is now forcing people to look at their external walls regardless. You know, so there needs to be a risk assessment done on your external wall, or if you're in a residential building that contains 2 or more dwellings. So EWS1 certification is for a specific set of buildings, but everybody should be considering the risk posed by the external wall if they manage a building with 2 or more dwellings on it.
Great, thanks, Mark. Next question I've got is for Berkeley. So Lewis, you're in the hot seat for this one. With the changes that have arisen due to COVID, we're inevitably going to see an increase in permitted development schemes in our cities, commercial to residential conversions. Are loans from Homes England Barclays also available for developments of this type? Are there any provisions to avoid financial support for schemes that provide inadequate or poor quality accommodation, regardless of whether fire safety provisions are acceptable?
There's quite a lot in that question, isn't there? So permitted development rights, I think, so the issues here are that fundamentally you're going to have higher density development in city centres, and the PDR rules were brought in to facilitate that. Which is a function of housing crisis pressure for resi. The short answer is, yeah, you can borrow money to do that. Would we fund it? I don't know. We would look on each deal on its merits. Are we going to fund effectively the slums of the future? Resoundingly not. So I don't know if that sort of specifically answers the question, but it wouldn't be our intention to do that.
Can I jump in? It's slightly off topic of the question, so apologies. But in terms of the permitted development situation, the regulatory changes that came through, there was permitted development for providing additional stories on buildings of a certain height. That, because of the requirement for sprinklers, has become particularly problematic. So if you go over 11 meters, you will require sprinklers. So what that has done for permitted development, where you were allowed to put additional stories, let's say on a 4-story building, you no longer can do that. Well, you can, but once again, you have to hire Mark and go into a lot of consultation with, especially if it's leaseholders, you have to go in consultation with them, because if you're providing sprinklers throughout, then yeah, it becomes complex, basically, and so complex that it becomes, well, probably not something that most people will try to look at. The value just isn't there on the term.
Thank you. The next question is to Hydrock. So Mark, back in the hot seat. Have you heard of injectable fire barriers, and do you see this as being a solution for some walls moving forward? And that's from Andrew Bannister.
Brilliant, thanks for that. Yes, I have heard of them. I mean, the great thing, you know, one thing to come out of this is that everyone is taking testing more seriously. I think, as Mark Rees alluded to, you know, we were building things and we were using materials that weren't efficiently tested. You know, these things are tested in a specific methodology within a specific construction, and one of our jobs is to make sure that the materials and the suitability of the materials used in the project is right, and it meets the building requirements. I have heard of the injected cavity barriers. We've actually approached a couple of companies to see test reports, and because on the face of it they sound great, and I think that's maybe what's happened in the industry, is that, you know, you hear about a product, there's a big flashy sign on the website that says, oh, this is fire rated. and then everyone goes to it and buys that without understanding how it was tested, what the purpose of it, you know, the actual orientation of that particular material as well. So yes, to answer your question, we've heard of it, we're looking into it. We'd love to, you know, have a bit of chat further. Feel free to get in contact and have a discussion if you know of any others that are being tested or used. It would provide, if these things work as they should, as they're tested, this would provide a great solution, because cavity barriers, you know, within cavities and insulated walls are one of the biggest key concerns, you know, where they weren't either properly installed, or they're missing, or they're, you know, fallen because some of them are friction fitted. You know, to get something like that in the industry would be a real winner. So yeah, hopefully they're as good as they say on the tin.
Great, thank you, Mark. I'm conscious of the time, and that we're up to 11 o'clock, and so I just wanted to thank everybody for their time today on behalf of the panel and of course to thank all my co-speakers. I hope you've all found the talk interesting and useful. If you do have other questions, please do feel free to get in touch with any of the panelists directly, and like I say, we'll be sending the video of this webinar hopefully this afternoon to everybody. So I think all that's left to say is thank you and goodbye.